Thank you, sir, for introducing me. You're given with the valuable introductions. What is I am doing in the patent office. Okay, thank you, sir. Uh, Today is World Intellectual Property Day. This is very good idea to spread the intellectual knowledge to the people to how to protect your intellectual. This is a very good idea, not required to only the spread the knowledge about the intellectual property to only on IP day. So I think it should be done regularly basis so that every people of the country to know about what is the intellectual property and how it should convert into the my knowledge into the into property. So office is mainly you trying to convert your intellectual mind into the money. So before taking the right, you cannot convert your intellectual creation into the money. Many speakers here given the what is the legality, what is the intellectual property part, like a design, patent, and trademark. All speakers, previous speakers, were very well explained that you should not with you should know if you created any intellectual property. So first of all, you have to go to office through the legal person, how to draft the your intellectual idea, how to write that idea, and then submit to the office. Because if you are not submitting your intellectual idea before the office and you present it in the public, after few long, you find out that this is my valuable creation. You should. This is the valuable things. I have to convert the money, but you may be too late. So office cannot protect you. Without taking protection, you cannot change your created intellectual property into money. Many Madam Darcy Madam explained that. Okay, what is the how assignment between the creators and publishers is done, like a assignment, like a mm, assignment or licensing. So before going to the assignment licensing, you must have to register with the office. Without registering, that will not take the your intellectual property as a assignment or license. That will not give a money or not converted into the valuable things. So office is very crucial for converting to your intellectual into the money. So first you have to know why office is giving the rights to you regarding the intellectual property. Office reason of giving the right to you to disclose what you have created. Suppose that anyone created very valuable instrument that convert your sound. Suppose some noisy sound, not your voice is much giving the pleasant to the listener. If you suppose you created songs or singing a songs, but that is not giving the more pleasant to the listener. So what happened next? Some people think that you have to create such an instrument that convert your song into very pleasant way. So that if that person invented the instrument, they have to protect it from the office. Without protecting that instrument may copy the someone and use that, then invented person that did not get any benefit. So you have to required to protect your invention first. Before going to disclose, you have to come to the office and submit your what you have been invented. There is some legality as well. The best way to go to the legal expert, also here organized by the um, Mr. Lex and Data Associate. This is the platform between the creators and the office. They all participants are mostly are the between the mediator between the mediator and the processor between the creators and the office. That will be very good way to come through the processor, intellectually protected processor, how to process the in the office, so that your very good way to write your intellectual property in systematic way that will be protected, and you can change your valuable creation into money. So I come first. Okay, what is the intellectual property? Intellectual property is creation of the mind. Everything what is created is the property, but there are some different property. The previous speakers also explained that there are the designs, trademark, patents, geographical indication, copyright, semiconductor integrated circuit, and layered data. These are the field of the intellectual property. So you have to know ki, okay, how it is protected. So first you apply the office, then some give the exclusive right. This is the exclusive right to you ki how to utilize it. Not any person can utilize your invention or design or trademark without your permission. If it is protected by the office. In case of the patent, all are already know that Dolby Laboratory and Sony, most famous in the field of the speakers and sound reduction system. These company are very well working. This company is actually take the right from the inventor. Instead of the created by the creator, they pay the some amount. Also, madam explained that regarding that, how they are benefited the creators. There are two way. The one way is the assignment, another way is the licensing. In assignment, they are take the money in one way. In licensing, may take the money in interval way. So, in case of patent, if you file the patent, from the date of filing, you get the 20 years exclusive right. Anyone cannot be copied from your creation without your permission. That person have to take permission from you. Very known inventors are like Thomas Edison and Graham Bell. You already know Wright brothers and Louis Pasteur, very famous inventor. So what is the benefit of this invented by this inventor? This disclosed to our society, then society is progress more and more. Then other person can know about this invention already happened. Then we have to invent further, or if there is any some problem in invented thing, then have to remove that problem. That removing the problem also is invention. That invention is two parts. One is novel and other is inventive. Inventive, novel means new idea. What is your new idea? You have to check in the world that your new idea is existed in the world or not. Many person I have experienced that many person comes in the office and find the patent and said that I have a new idea. So I ask question that you have searched in the world the very search platform are present like a Google and very non-patent literature is is published in that journals or many offices also publish in our journals. So you have to first of all, if you created any new things, so you have to search in the world. So that is actually already created or not. If not created, then you have to protect through the office, and then it will be changed into the money. Also, all people I think here participated. You very well know the famous game cricket. Cricket earlier, person you know that in cricket if a stump out or LBW happen to the game, then very difficult to the umpire to decide that is happened or not. Many times umpire gives wrong decision. So public become very upset. Nowadays, technically improved and many devices are installed in the wicket and also camera is installed on the outside. If it's, slightly ball hit the wicket, then create some noise. Then through the process, electronic process, then get the signal that is noise is generated by the wicket. That is very high improvement in the cricket game. So similarly in music, if anyone uh, invented the invention to reduce the background noise, very important for in music system to reduce the background noise. So a huge amount of invention also is done in the field of the music. So though that person he give the idea how the process the music to reduce the background noise, also create the pleasant sound, how to create the pleasant sound through the instrument. Like this, you should have to protect from the office, and that will be valuable for the world and for the country. I am coming to the next point. If you created in India, then not only protect from the India. If you created the valuable instrument, you must also have to protect it in the world. If you not taking the protection in the world, then what happen? Then many person will import in that country and utilize your creation. And also in there are many companies that will be create the your instrument what you have created. Then that company will be utilize your invention to create the instrument. Then there will be no benefit for you. So there are three ways to protect your invention. That are names ordinary, conventional, and PCT. Ordinary application means that if you created in India, then file the application only in India. Then only you take the protection in the India. Or direct filing in one country to take the protection. Convention application means there is some Paris agreement. Then according to that, there are many countries participating in that convention country. So if you take a file first your idea into India, then within 1 year you can go to the convention country to take the protection. You can file your application to the convention country. What country participating in convention country? You file within the 1 year from filing in India to foreign country to take the protection of your creation. Similar way, there is a PCT. There is also one agreement among the country that will give the more time to you to understand your creation is valuable or not, or also it is patentable or not. This is if you file in India through the PCT, Then what happened that if you file the first application in India, then within 12 months we file through the PCT. In PCT, some PCT examination centers also recognized in India. Some 7 8 country under the PCT who examine the PCT application. So through file there will be file, you can file the PCT application within the 12 months. After that application is examined or given the time to you 30 or 31 month from the date of the filing, from initial filing to file the in any country. If you feel that my creation is very valuable and it will be patentable, then you file in any country within 30 or 31 months, depend upon country what given the timelines. You can file your applications in that country within 31 months. If you go to the PCT, then PCT examine that your creation is a novel, inventive, or meet the some requirement or not. According to that, you can decide you go through the you have to go to the other country or not. You can decide depend upon you. Also given one provision for Indian application or other application. For Indian application, given is the provision of provisional patent application. What is the provisional patent application? If you file if comes idea regarding the any creation of music instrument and related device comes, but you have not completely your invention, but partially have given the input in invention from what is previously invented. In that you have given the some inputs. What it should be modified or what should be done, then what effect will become, synergetic effect. Then if you not completed, but there is partially some modification is done, then you come to the office, you can file an application in the office. After that, within the 12 months, complete your invention and submit your application. That is the relation between the provisional and complete. In provisional there is not required to the give the claim, but but within the 12 months give the details about your inventions with the claims and claims what you want to protect, what have you invented, like so you have to know what is the claim, like similar to the land property. If you buy any land property, give the some boundary. What is the boundary? You always mention that okay, which person is present your land, left, right, and left, like that dot, right direction, west, east, and south, north, like that. Mention that which person your land is present, north or south, east, like all name are present in the your agreement. Similar way, if you invented some of the invention, then mention in last you mention the claims, mention the important working features connected to each other that solve the problems. Further explain the features of the claims. Best way to, if a individual person, other company, best way to go through the service provider like a patent agent. That is many law firms are present in that. That will be very well way that will be draft and write your application. I already explained that what is the provisional. That is also maybe called the priority date. In convention case, there is in convention country some of creator. Suppose that you are participant of the convention country, you want to go through the convention country. You have file first in India, uh, partially complete your invention, not fully completed. And within the 12 months you completed your invention, then you can file in another country. Then previous partially completed application will be called the priority. priority application. All given that, wow, whenever that application is filed, that will be the priority date. So this is the concept of the priority date and priority application. A similar way also comes in PCT application. If you want to go to the PCT application, then also take the priority from whenever you file the partial application. That will be the priority date and priority application, priority document or priority document, and that will be protected from your invention from that time. I already explained that before going to creation or created, you must search in the world that type of instrument created or not. Or similar way, if you are a creator of the song, like in form of, if you are protecting the copyright, also you have to look into that is created or not in anywhere before your creation. There is some criteria of the giving the patent. That is a novel, inventive step, and also one most important criteria: what have you invented must be manufactured or is in India. Some also criteria that if you invented, but that will be. I already told there are intellectual property with different intellectual property. In the case of the patent, some comes if you come is copyright, that will not protected in the patent. For example, if you written the song, that song writing of a song will be not protected under patent because that is not a product or process. That will be artistic work that will be protected under the copyright. Similar way like a design. Some not giving the technical advancement, we are the giving the appearance, but looking. You have to know where many different types of bottle are used, but there is not giving the any technical advantage. All containers are only used for the containing the some liquids. So that will not come under the different types of bottle under the patent. That will come under the designs. If you are creating the any invention, most important things your invention must be technically advanced or it should be economically significant. It means must be cheaper than the earlier invention. Otherwise, it will be not patented.